Good morning and welcome to the premiere episode of Trusts and Estates Weekly, the next show in the Way to Wow shows series. And I am your host, Kevin Bemmel. And just by way of explaining what this is all about, for those of you who are not aware, so I am among other things, I'm a rabbi. For those of you who watched the show before, and I was a chaplain in the military for many years. And I started off life as having founded a commercial real estate company here in Los Angeles, and did over $1 billion in various types of transactions during the 20 years I had that company. So now I'm on what I jokingly refer to as Kevin 3.0, and am back in the business world. I am a California licensed professional fiduciary, as well as a licensed salesperson, real estate salesperson, a licensed life insurance agent, and also I'm registered with FINRA as a what do you call it, a registered representative for selling things like mutual funds and those sort of things, because I train people in the financial services industry. I don't sell products myself. Especially as a fiduciary, that would be a conflict of interest, as you will note, as you either already know or will be finding out as we join together each week on this show. So at the advice of a very close friend of mine who's been a guest on the show a couple of times, Bill Gross, who is one of the top probate real estate agents here in Los Angeles, he suggested that there was a need for a program where a variety of estate and trust matters could be discussed and presented so that people can learn what this is all about, not just for their own personal financial needs, but also for their business needs. So the position of a licensed professional fiduciary is a fairly new one in California. Whereas licensed real estate agents have been around for decades and decades and decades, professional fiduciaries have been around for only about, I think it's about 20 years now. And so a lot of people are not familiar with this particular area. And what professional fiduciaries do is they act as the sort of representative, or if you want, managing agent of among other things, trusts and estates. There are others who work with guardianships and conservatorships. And a fiduciary, of course, is someone who places the needs and interests of their client above their own. And there are many professions that have a fiduciary aspect to them. In the case of a professional fiduciary, all of our work is centered around handling matters for other people. So you can think of it if kind of like a business manager, only in what's the word I'm looking for? Sensitive cases. So take the example of a person who is no longer able to handle their own business affairs, perhaps because they're suffering from Alzheimer's, or they have some other debilitating disease, or they may be a minor, or they may be an adult, but they're not elderly. It's just for various reasons they're not able to look after themselves. So that's where a professional fiduciary comes in, and they go by various names: the guardian, conservator, administrator, and they can be brought in by the person while they still have capacity to do such a thing. They can be brought in by relatives. They can be appointed by the court. And we end up handling as much of the person's business affairs as is necessary. So the sort of credo, if you would, of a professional fiduciary is we don't want to take away from a client any more authority and decision making than is absolutely necessary. So we're here to help them maintain as much of their life as possible. So, for example, in an estate that I did a couple of years ago, so the woman, I mean, she didn't have Alzheimer's or anything like that. It's just it was too much for her, and she didn't want to handle it herself. And so she asked me to come and handle the matters relating to the death of her husband. And I did that with a lot of consultation with her and with seeking her input and, where at all possible, her decisions as to what would be done with her affairs. Okay. And in general, that is what professional fiduciaries should do. Now, I want to contrast that for a moment with, let's say, where the children of a person have brought in the fiduciary. Sometimes there's some confusion that since the children brought the fiduciary now is obligated to follow the wishes of the children. Now, that's not the case, okay? Because the business affairs being handled are those of the client, in this example, the parents. So what the children want isn't really the relevant issue here. And that can sometimes cause conflict, because what may be best for the client may not necessarily be best for the long-term interest of the children. And let me give you a situation I was involved in many years ago, where that created quite a bit of dissension, let's call it, among the various parties. So the client was an elderly woman. She was under conservatorship, and I came in to handle some real estate matters for her. And here was the issue. She was running out of cash to live, to pay for, she was no longer living in her residence. She was living in a retirement home, but she needed money to pay for the retirement home. And her liquid assets, her cash, essentially, was being diminished at a rate that it was going to be used up, to be blunt, before she was dead. And so additional cash needed to be found somewhere. And what that meant was she had two major assets. One was her house, which she didn't live in anymore. And the other was a portfolio of securities. Okay. Now, the way her will was set up was that one of her children would get the house, and the other child would get the securities. And if you're following this, you probably can see the conflict, right? So either the house would have to be sold to have the funds to support the woman, or some of the securities would have to be sold. And whichever one was done, that child was going to lose some of their inheritance. And the children, along with their spouses, started fighting. And I was brought in to do an assessment as to, what could possibly be done with the real estate, for example, that wouldn't necessitate selling it, but that might generate cash funds in order to support the woman who owned the house. So, for example, we looked at renting out the house. What kind of rental income would it generate? And the reality was, unfortunately, it wouldn't generate anything close to the amount needed each month to pay for the woman to stay in the retirement home. And we looked at a number of scenarios, and candidly, I don't recall what we eventually decided. But I can tell you that the children were unhappy. They were unhappy. As you might guess, they decided to litigate, which of course made the situation for their mother even worse, because now an attorney had to be hired, putting a further burden on her cash flow. And in the end, the court concluded that as her conservator, their obligation was to her. And while it was unfortunate the way the will was drafted, that was the way it was drafted. And she was not in a position any longer to change her will. But it was an object lesson. And so these are the kind of things that we're going to explore in this show for a half an hour each Monday morning to get us off started bright and early, get the brain juices going, as my friend Michael says. And so I'm going to wrap up, or not wrap up. I want to wrap up this example. So here's an object lesson that I learned working on this particular matter in talking with the woman's estate lawyer, and that is that in general, he told me it's not a good idea to dole out specific assets to your heirs, because if something needs to be done in your estate that requires selling one of those assets prior to your death, you've created a situation where your heirs are at odds with each other. So what he recommended is, rather than sort of trying to balance things out in terms of this person gets this asset and this other person gets this other asset, just give them a percentage of the estate. So each one gets 50%. And then at the end of the day, if when you pass away, you like this woman, you have this house and you have this stock portfolio, and they're worth roughly the same amount. Well, so then the heirs at that point could agree, look, why don't you take the house? You like real estate, you take the securities, you like stocks and bonds, etc. And, dos vidanya, as we say. Maybe I shouldn't be, quoting Russia, but, sort of dos vidanya, go with God. And if there can't be an agreement on how the assets are split up, so then the assets can be sold and the money divided up according to the percentage interests in the will, or hopefully not a will, because that has to be probated, but according to hopefully like a living trust or something like that. And so and this is one of the reasons why, if you have any kind of substantial assets, and I would say, substantial assets would be certainly $100,000 or more, and maybe even less than that, it will behoove you to get the advice of a qualified estate planning attorney. And I'm going to have some of them as guests on the show, because I think you need to hear from them. Now, maybe I should have started the show off by saying this. When I talk about these incidents and what the lawyers suggested, this is, of course, not me giving you legal advice. Okay, these are examples of how lawyers handled things for a specific client of mine in the past, or advice they may have given me personally based on the specific situations with which we were confronted. Your situation will not necessarily be the same. And so that's why I cannot recommend highly enough that when you're dealing with your own trust and estate matters, that you consult with a competent estate planning attorney and your accountant. Now, if you don't have an accountant, it may be time to get one. because there are so many complex issues when it comes to estate planning. There are tax issues, there are gift issues, there are valuation issues that your accountant can make you aware of so that you can do the best possible job in handling these matters. Now, I live in California, which if you don't live in California, you probably think of California somewhat as the crazy state, and probably not without justification. But in California, if you own a house, okay, I think most estate planning attorneys will tell you you should have a living trust, because that house alone, the equity in it is a large enough asset that you really don't, it will justify the cost of creating the trust, which isn't very expensive. And it will save you so much money rather than going through probate. Okay, so and I'm going to talk about just some basic concepts here, just in case you don't know. So when you die, okay, and you leave behind property, okay, so depending on what that property is, it may or may not automatically transfer to your heirs. Okay, now your heirs could be your spouse, it could be your children, it could be other relatives, it could be people who have no familial connection to you at all if you've established them as your heir in a formal